Hey folks, Rob Flux here for yet another Sunday session, the last one for the year. And so I've been doing a little bit too much Christmas celebrating, so my voice is a little hoarse. I'll apologise for that in advance. We've got a cracking show for you today. We're going to be talking about strata developments and all the legal ramifications that sit behind that and what you need to do in order to set up your strata management scheme and the like. In order to do that, we've got an expert coming to you, so Amanda Farmer from Your Strata Property. So Amanda, welcome to the show.
Thank you for having me, Rob. It's a pleasure to be here.
Now, thank you. Now, let's start with, I guess, a little bit of a terminology point of view, because the same concept that we're talking about applies everywhere around the country, but strangely, every single state calls it something completely different. So thought we might start with that, and then we can talk to and use the word strata moving forward, and it's going to kind of apply across the board. So now strata is a New South Wales government type arrangement. Is that correct?
Yes. So we do use the term strata here in New South Wales to describe what I see for this session you've called multi-residential developments. Which is a great term. I know the academics in our space often call these multi-owned properties. I like multi-res developments. We're talking about apartment buildings, we're talking about townhouses, community living. Now in Queensland, we call them body corporates.
Absolutely, that's where I am.
Yes, in Victoria, we talk about owners corporations. The term strata is just anathema in Victoria. In Western Australia, we have strata companies. So it can get a little confusing.
It can get a little confusing, absolutely. And where it gets even messier, and I'll add some wisdom for those out there that are doing subdivisions, you actually do a strata subdivision in actually carving up these things as well. So the word strata, as I understand, means the air, and that's subdividing in 3 dimensions. So that's just a little bit of a concept for those out there in the subdivision land. But you can also strata and have community titles in a land subdivision where you've got common driveways and all sorts of things like that. So there we go. We've got our terminology out of the way. But why the heck do we actually need a strata plan in the first place? Surely we can just give somebody a title and go, that's your property, off you go do that.
That would be a little bit scary when we're talking about parceling up airspace. And when you have an owner who buys an apartment, let's say for ease, they're really buying that airspace. That's what they own. And our legal system recognises that as a legal property right. However, when you've got an apartment building, you also have some property, some real property, some tangible property, and that is often shared with others. So you become a co-owner in what we call in most states common property. So you've got the lift, you've got the stairs, you've got the gym, you have the driveways, as you've said, you have the gardens. That is common property. So we have our airspace, our lot property, and then our building structure and surrounds our common property. And we need a whole system of laws to tell us how we properly deal with that property.
Yeah, so effectively exclusive use areas that are for you and you alone, and then the common areas that you have to share with others and play nicely with others in doing so. And so our role as property developers is to set up these rules up front so that the incoming person that ends up buying our product can play nicely together. And that in itself can be a little bit challenging. And you're going to go through some of the common issues and challenges that we actually see in there. But before we go too far into some of those, why should we be listening to you? So who is Amanda? What's your experience? Why are you the go-to person?
Well, I am what's known as a strata lawyer, and often I say that and I get a blank look. So then I go on to explain all about strata property, which I know your audience is should be pretty well versed in, having heard now the different terminology. I have been practicing exclusively in this area for about the last 10 years. It's an area that I adore because it is challenging, it is changing, there is always something new. There is always new legislation. Sometimes there is no legislation. And we as lawyers are trying to work out how to solve a problem for a client. So I have a legal practice in Sydney. I also have a podcast called Your Strata Property, and I love to educate owners, strata managers, developers. I work with local councils as well, because I just find in this area of the law, a little bit of knowledge can help you achieve so much. Sometimes what I can share in 2 minutes, in 5 minutes, can solve a huge problem for somebody in the place that matters most to them, their home or their biggest financial investment.
Yeah, and I've just put the link to your podcast. You just mentioned that as we flew. You've been running that for 6 years, I think you said.
Yeah.
Having run this show for about 3 years myself, that's a mammoth effort. So kudos to you for doing that. So,
thank you.
I'm sure that in doing the podcast over the years, you would have seen lots of different industry experts come through and lots of different issues and challenges raised. What's been your favourite episode out of all of that?
Oh, my favorite episode. That's really tough. I just sat down actually over the last couple of days and was looking at our top 5 episodes from the year 2021, which I like to do at the end of the year or the beginning of a new year. And one of our most popular episodes, and yes, my favorite, I was interviewing Ross Taylor, who is a waterproofing expert. And we were talking about waterproofing defects, building defects, and the remedial work that has to be done in our buildings to fix these defects. And he had a story for me where he said, Amanda, I went in to get a second opinion on a job, and the building had been quoted $2.5 million to fix a water defect. I think this one was a commercial building. And he said, I went in, diagnosed it, and it was an $800 fix.
Wow, that's insane.
That's terrible.
Yeah, absolutely. That's an episode I'm going to clearly go back and watch now. But you mentioned water defects. That's, I guess, one of the common issues that we're going to touch on a little bit later as we start to go through some of the issues and challenges that we have. But we touched on why, I guess, these strata plans are put in place. But I guess there's an element here of trying to get good neighbourly behaviour. And there's also an element of, hey, there's parts of the property that is actually owned exclusively by one owner and parts that are actually owned in common. And so there's issues with regards to warranties and repairs and all sorts of things. So we're trying to capture all of this in one place. And if we do it really well, then we create a nice harmonious environment. And if we do it really poorly, then the environment becomes a shambles a little later. And as developers, we tend to think about just the quick, easy, get it in, get it out the door, because we want a strata plan that's nice and cheap to run, so that the levies that are associated are quite low. So that might make it attractive for a purchaser to buy, but that actually makes it less attractive once they're actually in it and running and all sorts of things like that. So. So when we set these sets of rules up, right, there's a couple of different ways to do that. We can go and engage someone like yourself to try and create the rules, or we can actually engage a body corporate manager or a strata manager, and they will typically write that for free in exchange for, I guess, the management rights on that for the first couple of years. Now, I think from our chat the other day, you were saying that there's pros and cons to each of those approaches. And
yes, absolutely. I recommend that if you are, at least for the first time, developing strata title, that you do connect with an experienced strata manager or body corporate manager or owners corporation manager for our Victorians. And this is a person who should be used to working with developers, used to working with brand new buildings, brand new strata plans. And that person will be able to guide you as to the basic legislative requirements. You are going to be, as the developer, the original owner, and you have particular legal requirements that you need to be across. The strata manager can alert you to those. And I'll say alert, and then I'll come back to where you might need some more detailed advice. And yes, as you say, Rob, they can give you their templates and their standard form bylaws or rules and suggest that you put those in place when you register the plan. They can help you to convene the first annual general meeting and make sure that your agenda for that meeting includes all of the things that by law it must include. They can run that meeting for you. And yes, you're right. A lot of strata managers, body corporate managers do all of this work for a year or more ahead of that first annual general meeting, expecting, charging nothing, and in the hope, in the expectation that they will then be appointed at that first annual general meeting as the strata manager for the new scheme.
Yeah. Now, in some states, how long they can actually be appointed for is different. In New South Wales, I believe it's for 1 year. In most other states, it's 3 years. So they're basically trying to get in on the ground floor, get those first couple of years worth of management rights, prove that they're actually worthwhile, and if they do a good job, hopefully they don't get kicked out. That's really the plan, which then sets them up for a good 4 or 5 years worth of business. So good in concept. I'm sure you've seen, I guess, some issues where that has not gone to plan.
I definitely have, and I'm thinking of a particular situation at the moment. Owners are getting more savvy. Owners who purchase strata, who purchase community title, are getting more savvy, and that's because of ease of access to information. You can Google. We're getting more experts in the space, like myself, and they're understanding how these relationships work. And they're getting to the first annual general meeting, and they're seeing a motion on the agenda put forward by the developer saying, please appoint this strata management ABC company. And the owners are saying, well, why should we? What's your relationship with them? Who are they? What are they going to do for us? I know you like them and they've done all these things for you. We don't know them from a bar of soap. Shouldn't we have the opportunity? It's our home. It's our biggest investment. The opportunity to go out and find a strata manager that we like. You've got to be prepared for that. I'm seeing more and more of that now because owners are just becoming more educated.
Yeah, absolutely. Now, in order to put these documents together, I guess they have to be released. If you're doing selling off the plan, you have to release all of the documents within the disclosure documents. So, what is the exclusive use area? What are the common areas? And what are the rules of engagement under the different names around the place? In those instances, is it too late for anyone to actually have their say? Like if they're buying off the plan and the community management scheme or whatever it's called in the particular state, if that's already been written, is that too late at that point?
It is too late to have a say in the original bylaws. So let's go back, talk about those rules and those bylaws, and certainly in the structure of the development, where the common property is, where the lot property is. The bylaws that are in your contract or your disclosure statement are the bylaws that are going to be registered with the plan. So if there is something in those bylaws that that an owner is not going to be comfortable with, and I'm conscious that your audience, Rob, are property developers, so all of this is about marketing. If an owner is not going to be comfortable with something in the bylaws, maybe there's a courtyard or a parking space that has been left within the exclusive use of the developer, of the original owner, or of one particular lot owner. The purchaser is going to pick up on that and maybe asking some questions, and certainly should be made aware by their conveyancer or their lawyer advising them that there's really nothing they can do about that. That's a bylaw that the developer has decided to make on registration of the plan. And once the property settles, once the purchase settles, and the owners are then comprising the new owners corporation, the new body corporate, they can go about then changing the bylaws. Again, different states, different requirements for how you change bylaws. But certainly when I did a bit of conveyancing, when I was a junior lawyer, I would get these big fat contracts, sometimes from the big developers, and I would say to my clients, this is it, guys. If you want to purchase this property, then all the terms are there. There is no use negotiating with the developer about changes to the contract. It's just not going to happen. And if there's anything about this building or my advice that you're not comfortable with, then I suggest you don't sign the contract.
Or be prepared to take it to the annual general meetings and have your voice heard and run the gauntlet of trying to change that.
Down the track, yep.
So given that it's going to be set up in advance before the contract is actually signed, the developer writing these and putting these together, the developers has to look at, I guess, a balance of a whole bunch of things. So there's the balance of creating the amenity. There's the balance of, I guess, the maintenance of the property and the ongoing maintenance of the property and making sure that that's actually looked after. The balance of, with that management, I guess, not having too onerous I guess, a body corporate fee or a strata fee ongoing, sinking funds and things like that, because that makes it unattractive to purchase. But the developer is also going to look at, well, are they getting rid of the stock, or are they keeping some of the stock? Because if they're going to keep some of the stock, they might want slightly different sets of rules if they're going to be participants in there. And there's also things like, well, what kind of activities do you want to allow to actually happen inside the property? Some of which we think we have the ability to control, and might put some legislation in, but then find out that it's not necessarily, I guess, legally enforceable. So you've come across a number of those elements along the way. What are the common problems that you kind of see in these spaces? The issues that come up time and time again.
Yeah, thank you for highlighting that really important point that developers really need to be thinking about what they want to do with this property, because you're exactly right. If it is a property that you want to hold on to for a while, you might want to hold the majority of apartments, either for yourself or for your family, and then you're wanting to create perhaps a different type of community that serves you in a different way. If you're just wanting to sell, then you'll have a different intention when setting up, and you must be clear on that when you're putting together these development documents, because you can create bylaws. I've already hinted at bylaws that give common property rights, give exclusive use, but that must all be done before the strata plan is registered. Now, things to be aware of where all may fall apart, all may go wrong. We do have legislation, certainly in New South Wales, that recognises the power that a developer or an original owner may have when they're first selling off the plan and at the first few meetings, because developers may hold on to the majority of apartments, therefore they have the majority of the voting rights. But in New South Wales, we have legislation that actually reduces a developer or an original owner, we call them, reduces their voting rights by up to a third on particular motions. So be very careful that you may think that you have this power going in. I'm going to hold on to lot 1, 2, and 3 because that means I'm going to have the majority voting right. But if there is a new bylaw being proposed and a special resolution is required, then if you are the original owner and you hold more than half the unit entitlement, your voting right is going to be reduced. And that's a direct attempt to hamper your power as an original owner. And this is legislation that's only come in within the last few years. So important to be across these changes to the law. And that might be where, instead of your friendly strata manager who's helping you along the road, you need to be talking to a legal advisor about your intentions for the property and understand these nuances.
That's really interesting because I guess in Queensland there's also some issues with regards to the original owner of the property with regards to ongoing warranty works of the own building. So, for example, if there's a leak in, I guess, the roof of one property and a different one in the one that you own, because the developer was the one who was actually the one who engaged the builder, the developer is seen to be at cause for that building quality, for want of a better word. So the owner is actually not protected from the ongoing homeowner's warranty protection. Now, I think you mentioned that in certain buildings in New South Wales, homeowner's warranty protection doesn't exist at all for anyone.
Yes, so we do have legislation where the builder developer has to give a warranty of up to 6 years. We definitely have that, and that's across all states. What a building may not have and a developer may not need to get in New South Wales is homeowner's warranty insurance. So if you are building a building of 4 stories or more, then you're exempt as a developer from having to get insurance. And that means that if you sadly die, disappear, become insolvent, then you're not on the hook, and and owners who have a warranty breach in the building within that 6 years do not have anywhere to turn because there is no insurance. So definitely really important question for developers to be asking straight up, what am I building? And do I need to have homeowners warranty insurance?
Absolutely, and that adds a lot to the cost of the construction as well, because that's a mandatory part of the I guess the construction contract in most instances. So there's a whole bunch of knock-on effects there as well. Let's talk to the some of the bylaws that we see commonly creating a whole bunch of conflict. So pets is one that I can think of though, straight off the top of my head. If I'm wanting nice, peaceful lifestyle, I don't want pets in other people's buildings and that sort of thing. But if I'm a lonely person, I probably do want a pet. So do you want everyone having pets? Like, what can we do to restrict pets in these instances?
Not much is my short answer right now. That would not have been my answer last year. This time last year, the law has changed a lot in this space. Mostly in New South Wales and a little bit in Victoria. Queensland has, for the last few years, been pretty stable on pets. But the starting point is that you cannot restrict the keeping of an animal pretty much across the eastern states. In Queensland, a bylaw that does that is likely to be unreasonable and therefore invalid. And in New South Wales, a bylaw that does that is likely to be harsh, unconscionable, or oppressive, and therefore invalid. So lots of court cases about that over the last year and lots of media about that. And as a developer, I'm not sure if this is what you're hinting at, Rob, but as a developer, you can't say, well, this lot is allowed to have a pet. I'm making a bylaw for this lot, but the other lot can't have a pet.
I wasn't trying to be specific down to individual lots. I was just saying, do we want none in there, or do we want everyone to have them? But but you do raise a good point that we'll kind of loop around to, I think, which is what can we do that's exclusively to us? And I think there's a few things that you're going to tear shreds in some of those intentions, for want of a better word. But so from a pet's perspective, I can imagine that there's a whole bunch of bylaws that have been written many, many, many moons ago, before the state legislation existed, that does say that the pets aren't allowed. So I'm anticipating that there's going to be issues where some of those things are there and can and will be challenged over time.
Oh, yeah.
But it's the fact that a bylaw is written, sometimes people just comply because they think it's too hard. Is there instances where you might want to encourage certain behaviours that aren't enforceable, put something in, and just know that most people are just going to play along?
I get asked to do that all the time, Rob, all the time. I get an instruction, whether it's about a pet ban or a ban on hard flooring. That's another common one I'm getting now, a ban on hard flooring, because some buildings are just, the way that they're constructed these days, having hard flooring is causing a noise disturbance. So, Amanda, we want a bylaw that bans hard flooring. And, I have my template letters now. I get asked that often, that I say, well, here's the law. These are the reasons why I say a bylaw, most bylaws that ban anything outright are likely to be harsh, unconscionable, or oppressive in New South Wales, and therefore invalid. However, you've heard my advice. I advise, you decide. Taking Rob's point there, I do, in some of my education, I teach that bylaws are like no standing signs and no stopping signs. We drive our cars, we see them on the street, we're in a rush, we might take our chance and disobey the sign, and 90% of the time we might not get caught, but the sign is still there. Bylaws definitely, in most buildings, are there as no standing signs, and it is the rare case that they are challenged. It is the rare case and the rare owner that has the time, the money, to take an owner's corporation, which is the legal entity once the strata plan is registered, take an owner's corporation to the tribunal and challenge a bylaw. But you will never hear me say that that's a reason to put an invalid bylaw in place. I think you do, if you're thinking about going down that path of bans. We can talk about tenancies and short-term letting as well. That's another common area that comes up, that people want to regulate that area. Go in with open eyes, get your advice, and then decide where your risk profile is if you want to have bylaws on your books that are open to challenge.
Yeah, well, let's complete the little loop on pets, because there's a few other elements in that, I think, that where people try to put certain things in. So landlords try to put pet bonds in and things like that, which I believe is not legally enforceable either.
So it is important to differentiate between the owner's corporation or the body corporate that manages the common property and the strata building itself, and then an investor owner who is a landlord. In New South Wales, and I believe in Queensland as well, it's still open to landlords to say no tenants in my property are allowed to have pets, and that's legal. Not the case in Victoria, interestingly, and I think New South Wales will go that direction as well. But a building, so a landlord can ban a pet in their own apartment, makes sense, it's their own property, they can make decisions about what goes on in their airspace. A building in New South Wales and usually in Queensland cannot ban a pet for the building. So if the building allows it, then a landlord can consider whether or not to allow it. Now, some buildings, you talk about bonds, some buildings is becoming common in New South Wales since our law changed, are indeed passing bylaws, making rules to say, if you'd like a pet, sure, we know we can't ban it. Amanda told us we can't ban it. But what we do want is a $2,000 bond for the pet. If you want to keep Rover, $2,000. A bond or an application fee. And I agree, Rob, that those bonds are illegal. What I say a building can do, and if you're thinking about bylaws to this effect, what I think you need to do is say we can recover our reasonable expenses of having to deal with a pet application, $200 for the strata manager to have a look at it, put it in the file, and we can also recover any expenses we might incur dealing with damage that your pet has caused. So if there's costs arising from damaging the common property, we can recover that from you, the owner. But thousands of dollars for bonds or application fees, I say that is illegal. And we haven't yet seen these challenged. This is my view. I wouldn't be surprised if we did see them challenged down the track.
So how big can Rover be? Is Rover like this, or is Rover like what? Is there anything we can do to stop man-eating lions turning up into these properties that are really the size of a shoebox in some instances?
Another great question, and another bugbear for buildings and for pet lovers, pet owners, weight limits. Weight limits are very common. Can't have a dog over 15 kilos, or can only have cats and can't have dogs. I too say in New South Wales that bylaws that regulate according to animal weight or even animal type are now illegal bylaws. I recently got an advice from a barrister on a particular point, and together we both looked closely at the new legislation in New South Wales, and he came to the conclusion, I had a chuckle, that on a reading of this legislation, a resident can keep, to use your example, a man-eating lion in their property, as long as, and they can have that lion there quite legally, until it actually eats a man, and then it has to go. So that is how pet-friendly our new law is in New South Wales. Now, I say that very a bit cheekily because we, of course, have local council, local government regulations about what kind of animals we can have. So no farm animals and things like that in residential properties. But as for only having 15 kilo or less dogs, there is no... our tribunal has been quite clear that unless you're protecting owners and occupiers' use and enjoyment of the common property, you shouldn't be regulating the type of pet, the size of the pet. What you need to regulate is their impact on others.
The impact and behaviour of the pet.
Yeah.
Understood. Very good. What about things like you touched on before, no hard floors? That's clearly for noise implications and things like that. Is there anything that can be encouraged to, certain noise attenuations if things like that are to be installed? So you might say, yes, a hard floor is allowed, but in a compromise, you need to put X, Y, and Z in place to not impact your neighbour.
Yeah, absolutely. You can have a bylaw that regulates noise transmission, whether it's from floors or just noise transmission, full stop. I would like to think that most new developments now probably do have hard floors. I come across the as an original installation. And then you would have a bylaw that says if you are changing your flooring in any way, if you're changing it other than adding carpet, because that's not a problem, but if you're changing your flooring in any way, then it has the following requirements as to the 5-star acoustic insulation, underlay, whatever it is. Some buildings have a bylaw that says if you're changing a hard flooring, and indeed if you're doing any type of renovation, talk about renovations, make an application to the Strata Committee, the Executive Committee, the Council of Owners, and that committee will consider the application and tell you what their reasonable requirements are. That's often a good idea to add in some flexibility so that you can consider each application in its own circumstances.
Which then segues onto restrictions that might apply to any renovation works that might be in place. Now, noting that we're building a lot of brand new stock in this instance, but we still want to know, if somebody wants to modify it later on, paint their walls pink, purple, whatever, what is and isn't allowed in regards to that space?
Yeah, I often see investors trip up on this particular issue because they buy an apartment thinking that they will renovate it. Let's do the bathroom, let's do the kitchen, let's do the floors, and we'll turn it around in 3 months and we'll make a nice tidy profit out of that. Not so in strata land, because everything takes time. It takes time because you have to get the approval of the owners corporation, the body corporate, before you can do anything that impacts the common property. All right. Now, when we're doing a bathroom renovation, good example, we are touching tiling, we are touching waterproof membrane, we may be excavating some of the concrete slab below, depending on what we're doing. We may be dealing with common plumbing. The minute you scratch the surface, really, of what you can see on the walls, the floor, the ceiling of an apartment, you are impacting the common property and you need approval. And at least in New South Wales, when you are renovating a bathroom and dealing with waterproofing, that approval must come from the general meeting. Now, you can't force an owners corporation to have a general meeting just because you want one. You might have to wait for the next AGM. You might have to wait for when the next meeting is scheduled. And that is going to destroy your project timeline if you're not aware of that and you're not prepared for that.
And clearly holding costs and all those sorts of things that are associated with all of that. I'm sure that people will potentially try to run the gauntlet of that and start the works and that sort of thing. So what is the ramifications if they try to do that? Like, what can be done in order to stop works by the body corporate or the management committee?
Yes. An order can be sought from the tribunal for work to stop immediately, and that is then an order that must be complied with at risk of quite a hefty penalty, and those orders can come down within a few days. That would be a very switched on, very confident building, or perhaps with a lawyer on call who was able to do that promptly. What usually happens is that a neighbour comes and knocks on the door and says, hey, there's jackhammering going on. What are you doing in there? Looking around, trying to work it out. Oh, we're just renovating the bathroom. Oh, well, you need approval for that. And it's then going to be a matter for the owner who's doing the work, what their appetite is to continue with their illegal work in the face of this objection and this notification from their neighbour, and just set about doing it anyway. Certainly not something that I would suggest, not a great way to be the new kid on the block. And if you want to be the nice new kid on the block, then you stop, you wait, you seek approval. You probably have to go to a strata lawyer and have a bylaw or a motion drawn up that you can put to a meeting and seek approval for the work you've already done if you're halfway through, and then approval to continue your work.
And all of that can take time. And I can vouch for having had multiple properties where you want to get things through the body corporate. Time is something that is really not something they're really they've got plenty of, let's just say.
Yeah, seems to. Yeah. You're not the top of the list, let's say that. You have an investor owner who's just snapped up the top floor apartment, And what a community sees, and I say this from the perspective of having acted for these communities, they just see you coming in, wanting to make a quick buck, not wanting to contribute, not wanting to sit on the committee, not wanting to get to know any neighbours, maybe put a tenant in there who's going to cause trouble, be noisy and have parties. So we really don't have time for you, and we don't want to fast track that road to discomfort. So we're not going to pay attention to your request.
Which comes down to a really good point in, hey, actually go to the effort of actually getting to know your neighbours and become a good neighbour. Do the right things. I tend to like going in with a bottle of red and a bottle of white and go, hey, I'm your new neighbour. Don't know what you drink, but one of these is going to be empty by the end of this conversation. And that's usually a good way to break the ice and get to know them. That you can then reveal at that point, I guess, what your intentions are and how you want to work with them to make sure that you're not impacting them as much as humanly possible. So, yeah.
I do know.
Sorry, you go. Yeah.
I do know, being a resident in an apartment building and also sitting on my own strata committee, that personality plays such a role in decision making, in how fast somebody might move, in how flexible somebody might be, and those neighbours who take the right approach, as you're suggesting there, Rob, definitely have a smoother ride, let's say, and that I think that is just human nature.
Yeah. Okay, some other things that a developer might want to be putting into their bylaws might be, I guess, some either uplift or downlift of the way particular properties might be able to be leased out. So can it be done as short-term, short-stay, Airbnb, those sorts of things. So I've seen in many instances they might want to say, look, unit number 1 and number 2 can be used for Airbnb, but the rest of them can't. So how does that sit?
Look, I can speak to the situation in New South Wales. I'm not sure if this situation is different in the other states, but we certainly cannot have bylaws that restrict leasing. And I would say that a bylaw that says 1 and 2 can short-term let and 3 and 4 can't short-term let is a restriction on leasing and very likely an invalid bylaw. The other thing to be aware of in New South Wales is that we have a new section, again, new law, that says that you can have a bylaw that prevents investor owners from short-term letting. So another thing for your audience to be really aware of, check that if you are buying a property for the purpose of short-term letting and it's not going to be your principal place of residence, and that's the terminology used in the strata legislation, that you don't want a short-term let, and that they have if they have the bylaw in place, because you can be banned from short-term letting. But that's in our legislation. Any attempt to extend that and say principal place of residence or not, regardless, you can't short-term let, I say is illegal. And I also have clients who come to me and say, Amanda, can we have bylaws that say no tenants at all? No tenants at all. We just want owner-occupiers here. No, we can't have those bylaws.
So who is, so I guess what's the definition of short-term letting though? So is it a week, a month, a day? What's the definition on that?
So it's less than 3 months. Anything less than 3 months is short-term leasing, yeah.
Okay. So that's I guess you can't restrict it to individual units, but can you, with the exception of the, I've lost my question now, with the exception of that short-term, you can kind of ban that across the entire building. Is that kind of what I heard you say?
You can, in New South Wales, you can ban it across the entire building for properties that are not the host's, let's say it's the host's principal place of residence. So you can stop investor owners from short-term letting. You cannot stop owner occupiers if they are lucky enough sometime in the distant future to go overseas for 6 months and Airbnb and have somebody come in and stay or 2 people stay, one for 3 months and another for 3 months. You can't ban that, but you can ban investor owners from short.
And you couldn't ban them renting out an individual room on short stay, for example.
Correct, that's right. So the owner occupier who's just renting out the second bedroom, not a problem. Where we have some frustration here in New South Wales is that we see a lot of tenants who are subletting. on a short-term basis, and they're actually not there, even though their name is on the lease, and then they've popped the place on Airbnb and they're making a quick buck out of it. And we don't have a way at the moment to prevent that from happening, because it is indeed the tenant's principal place of residence, so we can't stop them short-term letting. The other thing to be aware of here is we have a code of conduct for short-term letting. We have heightened fire safety standards for properties used for short-term letting. So all of this has just come about within the last 6 months in New South Wales. So it's really important to be across that topic.
Yeah, there's actually an industry that does that encourages a master lease arrangement, and then once they have the master lease in place, then they sublease on those short-term basis. How would that play out in a situation like this?
Yeah, good question. If that the name on the master lease, the question would be whether they have, that still wouldn't be a principal place of residence if they're a corporation who are doing the master leasing. It would still be an investment, and there wouldn't be a tenant in there who is using that property as their principal place of residence, and certainly not the owner of the property is not using it as their principal place. So in New South Wales, they would actually be okay to be short-term letting that, I think.
Okay, interesting. Very good. Okay, well, there's plenty of other issues that we see in these spaces. So we've touched on pets pretty hard. What about things like, I think you said the 3 Ps, pets, parties, and parking?
Oh, yeah. Something, if I can tell your developer audience, please get some good parking arrangements in place, because the owners that I act for are just incredibly frustrated by parking problems. And hopefully in our newer buildings where we have secure basement parking, this is not so much of a problem, but definitely in older buildings where we have open air, open access parking, it's a really difficult problem to deal with, because owners don't have the right to go and wheel clamp, don't have the right to go and have a vehicle towed. The police don't want to deal with it because it's on private property. The council doesn't want to deal with it, and our strata legislation doesn't arm our owners with enough power, I believe, to deal with illegal parking. So paying attention to good parking arrangements, I think, is going to make your property a popular one when it comes time to sell.
So the owners themselves don't have that power, so they can't put that into their own rights. But can they escalate that up to, I guess, the owners' corporation or the committee to actually enforce themselves?
Yeah, and that's what's happening. And the committee doesn't have any power. The committee doesn't have any power to move a vehicle, doesn't have any power to wheel clamp a vehicle, doesn't have any power to tow a vehicle. They have to go through a rather convoluted process of declaring the vehicle an abandoned good or an uncollected good, and follow the process in the 1955 Uncollected Goods Act, appointing an administrator, listing it for sale. Look, that's where you have an abandoned vehicle that's there for months, and that's not the common problem. The common problem is members of the public parking in our visitor parking space, residents who are not visitors parking in the visitor parking space. Definitely step one to addressing that problem, I always advise, is to have a bylaw in place that regulates the use of the visitor parking, regulates the use of the parking areas, and then enforce that bylaw. Actually enforce the bylaw against the culprits.
So I've seen many instances where there's signage on the visitor car parking that says, park here and you will be towed away at your expense. Is that one of those things where it's all bluff and bravado?
Yep. Didn't hear from me. And of course, I've never drafted any of those signs and ever handed the copy over with a disclaimer. Yeah, so definitely in New South Wales, I've given some advice in WA as well, where the line is a little bit greyer, interestingly, in WA, but I think it's the same across Queensland and Victoria, that if you attempt to tow or deal with someone else's vehicle, that's a trespass, and that is not permitted, and there's no legal avenue for you to deal with that vehicle. Of course, the minute the vehicle's out on the street, on the public street, it's a different problem and somebody else's problem.
Yeah, I've seen quite a lot of this, and I don't know how big it is in New South Wales, but in Queensland, it's massive. where the tow truck companies actually create a massive business out of this because they know that they get massive revenue out of enforcing people to pay to get their car back. How, given what you've just described, I'm anticipating that they're effectively stealing the car in order to, I guess, take it off site.
Look, I have to be careful about Queensland. Maybe there is a different provision in Queensland legislation that allows that to happen. Not in New South Wales. We did attempt to, that would be stealing. To answer your question, in New South Wales, yes, that would be stealing. There was some legislation a couple of years ago that allowed an owner's corporation to move a car after it had been there for 5 days. But stupidly, I say, that legislation was repealed in July, I think it was this year or last year. So even that's not there for us anymore.
Yeah, and 5 days is such a short period of time. Somebody can move the car on day 4 and restart the clock.
Exactly.
You're driving to and from work, so you're leaving almost every single day and then go back and park illegally again. That's I guess repeat offenders would be a better version of the bylaw. Yes. Okay, so that's parking. So I guess a nightmare to actually manage that. So not much rights at all, and certainly nothing for the owners to actually do. They have to have that bylaw in place. Other issues, parties, like what can we do there?
Noise. It's a good time to be talking about parties as we move into Christmas. Depending on where you live, you may. I know I live in Sydney's eastern suburbs from time to time. I have 2 homes at the moment, but when I'm there of summertime, it's party central, and everyone's enjoying the weather and the view, and it's Christmas time, and it's barbecues and it's balconies, and inevitably there are noise complaints. So again, having bylaws place that regulate noise. Our legislation, all of the legislation in our various states has a set of model bylaws, which developers should certainly be across, and there is a standard model bylaw about noise. Enforcing that bylaw by issuing notices to comply and ultimately penalty notices and penalty proceedings in the tribunal, I suggest, is the course there to avoid those repeat offenders. But of course, a noise issue is the perfect issue or the best issue where you should simply be knocking on the door and talking to your neighbour and saying, hey, did you realise I can actually hear all of that? I can hear what's going on upstairs, and can you please keep it down?
Yeah, and where it gets really tricky is the party only lasts for a few hours, and the people you need to complain to are the body corporate themselves. Body corporate aren't going to answer at that hour. So by the time it actually gets enforced, it's too late. The party's gone. And so what are the repercussions afterwards?
Yes. So again, in my view, this comes down to clever bylaw drafting. I advise buildings and owners who are trying to deal with this issue to draft into their bylaws an obligation on the owner of the apartment, not just the occupier. Okay, so it is the occupier, it is the resident who's creating the noise. If you just use the standard model bylaw, then that is the only person responsible to comply with the bylaw. And as you say, they make noise, they stop, they're tenants, they come and they go. By the time there's been a letter issued, a tribunal application made, a penalty notice, they're long gone. But if you leave the owner on the hook, the owner is more long-term. The owner, particularly if they're an investor, money talks. We don't want to be getting notices from the tribunal about penalty orders. If you draft your bylaws cleverly to put the owner on the hook together with the occupier, then you're going to have more success. The owner is then going to be conscious of who they're signing leases with, what kind of tenants they're putting into the property, and learning that, okay, this is the community that doesn't put up with this kind of behaviour, so I'm going to be very careful about who I agree should be tenanting the property.
Yeah. So what about what might, I guess, be common property, community space, but where people want to actually have exclusive use of some of those? So it might be a rooftop garden or something along those lines. What can be done in this instance?
Yes, so definitely we can make bylaws that give rights to lot owners to use the common property exclusively. So rooftop is a good example, courtyards, sometimes parking spaces. These rights can be created by way of bylaw, whether before the registration of the plan, the developer might create these bylaws, or after the registration of the plan at an annual general meeting. What's really important to understand with these bylaws is that they're not watertight, that they are not legal property rights. It's not as if you own that part of the common property in the same way you own your apartment. What you have is a right to use. You don't have a right of ownership. And I've been involved in a case where an investor owned the top floor apartment of an old red brick walk up, and there was a bylaw on title that allowed them the exclusive use of the rooftop. And they were on the North Shore, they had beautiful ocean views, and they'd had that bylaw in place for many, many years, something like 15 or 20 years. And I was briefed by an owner who said, Amanda, we don't think this is fair. They never paid anything for that right. It's an incredibly valuable right, and it's not in the best interests of the community that they continue to have that right. And I had that bylaw set aside by the tribunal. So the tribunal can remove those rights. So when I have people ask me, Amanda, we want to purchase part of the common property. I understand that it's quicker and it's easier if we just do that by way of a bylaw instead of actually doing a subdivision of the common property and purchasing it. I'm always careful to advise on the pros and cons. Might be quicker, might be cheaper, but it is certainly not as secure a right.
Well, and equally, even if it doesn't go all the way through to the tribunal, I'm anticipating being a bylaw, the remainder of the tenants could all gang up together and vote against that bylaw and vote that bylaw out.
Yes, they can certainly try to. In New South Wales, to remove a common property rights bylaw that way, you do need the consent of the owner who has the right under the bylaw. But that is, of course, indeed, the process is putting forward the bylaw for what we call repeal the bylaw, ask for the consent. If the consent is not forthcoming, then it proceeds to the tribunal.
Yeah. Okay. Lots of things to be thinking about. Any other common challenges? Let's talk to, for example, brand spanking new building put in place. There's, I guess, parts of the property that are owned by the owner, and there's parts that are owned by, I guess, the body corporate or the strata. Where does warranties and insurances and that sort of thing for the building actually? Where are the boundaries where all of this kind of kicks in to say, well, if I've got a fault on one side of the wall, it's my problem. If it's on the other side of the wall, it's someone else's problem.
Yes. So the owners corporation, the body corporate, is responsible to repair and maintain the common property. And this is legislation right across our country. All our strata title acts all say the same thing. Owners corporation responsible for the common property. So you're right, it's really important for an owner to be aware of where this boundary of the common property and the lot property is. So if I'm in the penthouse apartment and my ceiling has a damp patch and I'm getting mold, and when it rains, it drips, that is a problem with the roof of the building. Perhaps the waterproof membrane on the flat roof after 25 years is no longer working. That is a common property issue, and the owners corporation is responsible for fixing that. They are also responsible, at least in New South Wales, for the consequential damage to your property. So you might have a built-in wardrobe under that particular part of the ceiling. You might have carpet. You might have paint. All of that is lot property, but because it has been damaged due to the common property not being properly repaired and maintained, then the owners corporation is on the hook for that further damage. Well,
which means you then have to put a claim through to the owners corporation. Owners corporation is going to take their time. They're going to get the committee to vote on it. They're going to go get 3 quotes. Just drags on and on and on. I can vouch for one of my properties with the exact issue you're talking about with a leaky roof, and it's a year so far, and the roof is still leaky and still not repaired because the can just gets kicked further and further down the road over and over. Is there anything that can be done to accelerate that?
Yes, you can go to the tribunal and seek an order forcing the owners corporation to act. And I don't just say this because I'm a lawyer and then I litigate and that's what I do. This is actually the process to getting these problems fixed. And sometimes it's just filing the application, showing the building, showing the owners corporation, hey, I know what my legal rights are. I know what your legal obligations are. And I know that this is the avenue I need to go down to get attention on this issue. And sometimes that's enough. You don't have to go through to a full-blown court case.
Yeah, which would be long, drawn out, expensive, and a major pain for everyone, I'm sure.
Yeah, definitely. And,
Okay.
a building is going to be told the duty to repair and maintain common property is one of the clearest, strictest, most absolute duties in the strata law. So if a building goes to get any advice, or even Googles the question, for heaven's sake, they're going to see a direction to, you can't get out of this. Doesn't matter if you haven't got the money, you've got to find the money to do it. It must be done. There is no excuse not to be repairing and maintaining your common property.
Yeah. So let's cover. You touched on the owners corporation looking after some of those elements, but let's see if we can list what are the things that fall into the owners corporation responsibility and what falls into the owners themselves responsibility. So roof, common walls, common areas. I think you said original waterproofing of membranes and tiles and that sort of thing in bathrooms.
Yep.
Balconies, and I guess the tiling that sits on there, sliding doors. Are there any other things that I'm kind
That's a
of?
very good summary. That's a very good summary. The slab, the concrete slab, we talk about concrete cancer in our older buildings. So whether that's the balcony or whether that's inside your apartment, the concrete slab is going to be common property. Be careful about windows. I think the situation is different in different buildings in Victoria in particular when it comes to windows. But yes, common walls, are often structural walls. The starting point for working this out is to have a look at the strata plan. There is actually a document called the strata plan. Your developers will know that, but maybe those not familiar with development wouldn't know that. And that has some thick black lines on it, and the thick black lines are what we call boundary lines, and they are where the boundaries of the common property are. There is actually very little that an apartment owner, a lot owner as we call it, owns in strata, and that's why we started off talking about airspace, because that's kind of it.
Yeah, we're subdividing three-dimensional space. So yeah, I think that's been a really good summary, Amanda. What we'll do in a sec is we'll jump over and see if there's any questions from the community. Is there any, I guess, parting thoughts that we've missed so far before we go and grab some questions?
Well, I do want to be clear that as a lawyer dealing with problems, when you hear me speak about strata, you hear often all the bad stuff. And I don't want your audience to think, oh my gosh, strata, I'll never touch it. We need good developers. We need quality stock. We need people in watertight, stable, sound homes, please. So don't at all get turned off by hearing us talk about the difficulties in strata. If you go in with open eyes and with good guidance, then you can be building these great properties, and no doubt profitably, and building great homes for the future. So please stick with us.
Absolutely. Okay, well, let's go and listen to the audience and see what they've got to say. So plenty of people saying hi. So hi to Kevin, Tony, Cheryl, Tomas, and a whole bunch more. One in particular, I'm not sure if I'm pronouncing this right, Zlata, that clearly knows you, Amanda.
Zlata, yeah. Hey, Zlata.
How are you? Emelana says, hi, Amanda and Rob. Thank you very much for... Oh, okay, it's just another thank you. Lots of thank yous. I'm trying to find the actual questions. Kevin's got one. Hi, pets are a contentious issue. Could a pet... sorry, let me rephrase that. Could a pet be allowed for ground floor unit owners where they've got a garden space, but not for other units that don't?
I'm going to say no to that, Kevin, because once again, we're talking about a ban. We're talking about banning a pet, full stop, without actually taking into account the impact that pet has on other occupiers' use and enjoyment of their lot and the common property. So what you're, and again, I speak with my New South Wales hat on, but what you're attempting to do there is make a call about that particular owner and the way that they deal with their particular pet. And our law in New South Wales just says, no, that is just not on. It is not your business. It is not your business what that owner does. They might have a dog walker who comes every day and takes the dog out. They might take the dog to the park 3 times a day. It is not for you to regulate their day-to-day relationship with their animal. All you can regulate is that animal's impact on others. And saying a dog can be in the courtyard but not in the high-rise is not regulating the impact on others.
So you could comment on things like not too much barking and, not defecating in public areas and things like that.
Have a bylaw that deals with all of those things. Absolutely. I think that's essential. You have to have a bylaw that deals with the outcomes of keeping the animal, but not the fact of keeping the animal.
Understood. So another question again from Kevin. So does the 4-story limit for developers not requiring insurance include basement parking? So the basement is in many instances deemed to be a story of some description from a development perspective. Does that count towards the insurance side of things that you're touching on before?
Yep, it doesn't count, and you do need to go and have a close look at the way the stories are defined. It's in the National Construction Code, and the last time I looked it up, it does depend on the height of the story, what is in the location. So generally, if it's a residential dwelling, people are living there, it's going to be counted. So that's why basement parking is not counted. And also how much of the story is above ground. So sometimes we have some unique developments where part of the level may be above ground and part of it may not be. And then there will be a different calculation. So not a call that I would suggest making on your own. If you are not sure if you need insurance, then get some advice on that.
Absolutely. So Tony's got a question. Can a strata manager enforce no parking in a visitor parking space? Now, I think we've already covered it, but they may have not been on the call at the time.
If you have a bylaw in place, when you talk about enforcement, the question is, well, what are we enforcing? We don't have legislation that says no parking in a visitor parking space, but communities have the power, this amazing, wonderful power to create their own bylaws, their own rules. This doesn't happen anywhere else in property law. It's very exciting as a lawyer. You can actually create a rule that regulates your own residents. So if you've got that bylaw in place that says residents cannot park in visitor parking, then yes, it can be enforced. And you asked specifically, can the strata manager enforce it? A strata manager is a professional engaged by the owners corporation, the body corporate. They act on instructions. So if you instruct the strata manager to enforce the bylaw, then they can take the appropriate enforcement steps, but you need to give them those instructions.
Very good. Another parking question. Could a bollard be put in place for visitor parking, and that bollard be then removed if the space is booked or reserved or something along those lines?
Yes, absolutely. Great idea. That works really well in buildings that have a building manager or a concierge who is there and available to take bookings, go out, remove the bollard. Yes, that is often something I recommend for buildings that are having trouble with parking, but you can imagine it doesn't necessarily work in those smaller buildings or where there is just no full-time building manager, caretaker there.
Yeah. So this is more a question for me. So hope there's a recording of today's session because they're having a lot of audio issues at their end. So the answer is yes, Cheryl. These are, I guess, saved on our YouTube channel, saved in our Facebook Live, and also saved on our LinkedIn channel. So you can get it from any or all of the above. So make sure that you go and reach out for that if you're having troubles. Tony's got another Tony's just got another comment. So we've got thanks for all of the responses and questions. So Amanda, I think we've done a pretty good job here and answered the questions before they've come in.
Glad to hear it. Thank you.
So I want to say thank you very much for making your time available today on Sunday, being our very last session for the year, and for anyone who wants to get hold of Amanda and her podcasts. These are the links down here below. So Amanda's been running that podcast for about 6 years. Plenty of stuff on Amanda's channel, and you may see me on there as a cameo at some point in the future. You never know. All good. So thank you very much for your time, Amanda, and to everyone out there. Thank you for supporting us for the last year. We look forward to seeing you again in the new year. So until then, bye for now, folks.